We now turn to the next case on this morning's docket. It is case number 118693 in the matter of Laura M. Owens. Yes, thank you.
Thank you.
Okay.
May it please the court. Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving Laura M. Owens, an attorney who was admitted to the practice of law in 2005 in Kansas. This matter involves 2 separate complaints, DA 12560 and DA 12716. DA 12560 concerns Ms. Owens' failure to timely file a lawsuit on behalf of client GT in Missouri State Court, failure to adequately communicate with GT regarding his lawsuit, and failure to cooperate in the subsequent investigation of the disciplinary complaint GT filed against her. The second complaint, DA 12716, concerns Ms. Owens' representation of AR for the purpose of amending AR's daughter's birth certificate. AR and PC consulted with Ms. Owens in July 2015 about amending the birth certificate. PC at that time advanced $2,000 to Ms. Owens for that purpose. Thereafter, Ms. Owens failed to get any pleadings filed in court. She failed to respond to numerous inquiries from AR and PZ regarding the case, failed to provide a billing statement to PZ after she requested one, and failed to timely refund the advance PC provided to her. Finally, Ms. Owens failed to cooperate in the investigation of the disciplinary complaint that PC filed against her. These 2 matters proceeded to a panel hearing on May 16, 2017. Prior to the hearing, Ms. Owens entered into stipulations regarding the facts and rule violations. She also made a timely request under Supreme Court Rule 211G to be placed on probation and submitted a proposed probation plan. Though the probation plan identified several conditions that Ms. Owens was willing to comply with while on probation, her plan did not identify a practice supervisor who could confirm to the Disciplinary Administrator's Office that she was complying with the terms of her probation plan. At the hearing, the main issue before the panel was determining the recommended sanction for Ms. Owens. At the hearing, Ms. Owens indicated that she had not found someone to act as her practice supervisor. As an accommodation to Ms. Owens, the Disciplinary Administrator's Office requested that the hearing panel keep the record open for 45 days to allow Ms. Owens to get a practice supervisor in place who could confirm to the panel and to the Disciplinary Administrator's Office that she was complying with the terms of her proposed probation plan. We also requested that Ms. Owens submit evidence during that 45-day period showing that she was complying with the terms of her probation plan. Assuming that Ms. Owens complied with those requests, the Disciplinary Administrator's Office stated at the hearing that it would recommend that Ms. Owens be placed on probation for 2 years. However, if Ms. Owens failed to comply, we would be recommending that Ms. Owens be suspended for 6 months and be required to undergo a reinstatement hearing under Supreme Court Rule 219. When the hearing concluded on May 16th, I was fully expecting that Ms. Owens, during the next 45 days, would get a supervisor in place and submit evidence to us showing that she was complying with the terms of the probation plan. Unfortunately, that did not happen. On June 30th of 2017, the final day of the 45-day period, Ms. Owens submitted a letter to myself and the hearing panel members which identified attorney Carly F. Booth as her practice supervisor and merely stated that Ms. Owens and Ms. Booth had met to start the practice monitoring. Believing that this letter was insufficient to show compliance with the proposed probation plan, on July 5th, 2017, I filed an objection to Ms. Owens being placed on probation. In my objection, I recommended a 6-month suspension with the requirement that Ms. Owens undergo a reinstatement hearing under Rule 219. The hearing panel issued its final hearing report on December 8th, 2017, concluding that Ms. Owens' conduct violated Kansas Rules of Professional Conduct 1.1 competence, 1.3 diligence, 1.4 communication, 1.15b safekeeping property, 1.16D, termination of representation, 8.1B, failing to respond to a lawful demand for information in a disciplinary matter, 8.4D, conduct prejudicial to the administration of justice, and Supreme Court Rule 207, failure to cooperate in disciplinary proceeding. The final hearing report was docketed with this court on December 13th, 2017. Ms. Owens filed a timely exception to the hearing panel's report. Specifically, she took issues with paragraphs 7 through 10 of the report, findings of fact made regarding her failure during the 45-day period to provide evidence that she was complying with her proposed probation plan, paragraphs 33 through 43, findings of fact regarding DA 12-716, the complaint involving AR and PZ, and paragraphs 44 through 68, which concern the rules that the panel found were violated, the panel's application of the ABA standards, and the panel's recommended sanction. In Ms. Owens' subsequently filed brief, she raises two issues before this court. The first issue, she argues that there was insufficient evidence presented at the hearing to show that her conduct in DA 12-716, the complaint involving AR and PZ, violated either 1.15B, safekeeping property, or 1.16D, termination of representation. Ms. Owens contends that because she ultimately refunded the $2,000 to PZ, albeit 4 days before her panel hearing, she did not violate either rule. In making this argument, Ms. Owens fails to acknowledge the stipulation she entered into, where she concedes that after receiving the $2,000 advanced from PZ on behalf of AR in July 2015, excuse me. After receiving the advance, she failed to get any pleadings filed in court to amend the birth certificate. She stipulated that she failed to respond to numerous inquiries from PZ and AR regarding the status of the case. She also acknowledged that in October 2016, more than a year after being retained and receiving the money from PZ, PZ contacted her and asked her for a billing statement, and that she failed to provide one to PZ. In addition to these stipulated facts at the hearing, Ms. Owens testified that her anxiety prevented her from moving forward with AR's case, and that she failed to properly terminate her representation of AR. And lastly, Ms. Owens testified that it was not until May 12, 2017, 4 days prior to the formal hearing, that she mailed a check for $2,000 to PZ. Accordingly, I contend that based on Ms. Owens' stipulation and the other evidence that was presented at the hearing, there was sufficient evidence to support the hearing's conclusion that her conduct violated 1.15B and 1.16D. Her untimely refund of the money 4 days prior to her disciplinary hearing did not cure these violations. The second issue that she raises in her brief concerns the sanction to be imposed in this case. Ms. Owens contends that she should be placed on probation and makes the argument that she did comply with Supreme Court Rule 211G in requesting probation. In making this argument, Ms. Owens fails to acknowledge in her brief that despite having 45 additional days to do so, she failed to present evidence from a practice supervisor or from herself showing that she was complying with the terms of her probation plan. Furthermore, she does not claim in her brief that she put her probation plan into effect prior to the end of the 45-day period. And finally, she has not provided an affidavit to the disciplinary administrator's office or to the appellate clerk's office stating that she is currently in compliance with her proposed probation plan as required under 211G5. Accordingly, because of Ms. Owens' failure to comply with 211G, I would argue that Ms. Owens should not be placed on probation. I recommend to this court that it follow the recommendations of the disciplinary administrator's office and the hearing panel. Ms. Owens' license be suspended for 6 months, and that she be required to undergo a Rule 219 hearing prior to her reinstatement. And with that, that concludes my prepared statements. Unless the court has any questions of me, I would waive the remainder of my time and address any concerns during rebuttal.
Do we have any questions? Thank you, counsel.
May it please the court. Thank you. My name is Laura Owens, and this is not a good day for me, obviously, but it's better than it has been for a long time. I think that's important for you to know, and for me to be able to stand here and speak with you is important, because I think, obviously, I've admitted that I've made mistakes. I made mistakes on The first case, I made a mistake. We all make mistakes. And I didn't file this lawsuit within the statute of limitations. And I've paid dearly for that, both civilly and then here in front of you guys. I've been censured by the Missouri Bar as well for that conduct. And I've had to face a lot of truths about myself. And while that was going on, so did this other case happen. And it's not as simple as the disciplinary office presented in its oral argument today. And I think that the testimony at the hearing really talks about the complexity of that, because that was not just a single client. We had one client. There was only one client, the parent, and then there was the grandmother. The grandmother was not a client, was never a client, and I said that. Was never a client.
I thought there was evidence of a fee agreement and a waiver of a conflict that they both signed, that with those documents indicated they were both clients.
There is no fee agreement with the grandmother. There is a waiver of a conflict of interest that I had them both sign at the initial consult, because they were both in that consult. And at that consult, I had them both sign because it wasn't clear to me. Because here we had a mom that is on, says she's on the birth certificate as the natural mother, and then we have the supposed paternal grandmother. But I don't even know that for sure, because we don't have any DNA testing. There's nothing that has that connection. So I did have them sign the waiver of confidentiality to have at the beginning of that initial consult, because my concern was that the daughter, the mother of the child, not the grandmother, might disclose something. For example, if I said, "Are you sure the gentleman is the father?" she might disclose something that in that might be in conflict with what the paternal grandmother, the alleged paternal grandmother, was wanting. So I did have a concern about having even the initial consult with them both being present in the room. So that's why that was, but then in the end, there was no client relationship proceeded, just with the mother of the child. In terms of why it didn't get filed, we needed the birth certificate, and I never received the birth certificate from the mother. Now, the grandmother did call, but at that point, because I'm missing information from the client, now I'm in a real pickle, right? I can't disclose to grandmother, which is what I told her. Hey, I can't talk to you about this because you're not the client. Had the daughter call. And I did admit that I missed, I think, 2 calls from her right before that, before the complaint was filed. I was in trial. I'm a solo practitioner, and I did not get it timely returned, but not so untimely as to warrant, I think, an ethics violation for those 2 unreturned calls when I was in trial. So so that case isn't as simple as the disciplinary office presents, is that, hey, I just sort of dropped the ball. There was more complexity, as there often are in family law matters. It's very complex, there's a lot of emotions, and certainly that was one that was fraught with it. But I contend I didn't do anything improper in that particular matter. I will fully admit that I did make a mistake in the initial complaint. It's very hard not to use their names. That I didn't timely file. And then I did the thing that I tell my own clients not to do, which was I stuck my head in the sand a little bit, and I got freaked out, and I shouldn't have. But when you make a big mistake like that, you learn big too. And I've learned big. And I think that's part of the reason why I'm very happy that I'm able to come here today and look you guys each in the eye and admit when I've made a mistake. And because you've got to, as I've sort of saying to myself, you got to eat the frog. It's kind of do the worst thing that you can imagine doing. And this is one of those things for me. This is the worst thing I can imagine from a professional standpoint. That lady before me, she had worse things, obviously, that happened to her. That's the worst. Losing a child and that sort of stuff. Professionally, this is the worst. But I'm here eating that frog. Why? Because I want to continue to practice. I know I'm a good attorney. And I know this because I can practice, and I'm still practicing. This has been going on for 2 years, and there hasn't been any other complaints. I'm a good attorney. I serve my clients well. I love my clients. I'm passionate about them. And I know I can do this. And yeah, I've made some mistakes and I've stuck my head in the sand, but I'm not doing that anymore. I'm eating the frog. Every day I get up and I eat the frog. And then I do the other thing that I think is very important, because we're all going to make mistakes, right? We're professionals. And this is high stakes. Is when you make a mistake, you got to look yourself in the mirror and say, I made a mistake. But then move on. What am I going to do differently? And that's what I'm here to tell you. I'm ready to do that. And I haven't always been, but I had to get through that. And maybe I didn't do it in the way that traditionally people do, go to therapy, and that's not who I am. I think everybody has to kind of deal with things in a way that they can do it. Now, I've gone to my doctor and I've taken the anxiety medications, and that has helped. And I don't need them on a daily basis anymore. I need them situationally. Although I am proud to say I didn't take one to come here today. And I consider that a huge thing, because in the past I would have needed something to get me through today. But I'm here and I'm functioning, and I can do it without the anxiety medication. But I know I can do this, and I know that I'm a good attorney if I could just get that one more shot.
Counsel, what are you
Yes.
asking us to do?
I'm asking you, quite honestly, I mean, I really think at this point it's been 2 years, and I've been successful with no other complaints, no other problems. I serve my clients very well. I think a censure would be appropriate, because I have served a pittance, and I will tell you, I scaled my practice back dramatically in Kansas. I only have 2 cases currently in Kansas, and in Missouri, I think I have maybe 4 or 5. And part of that reason is I needed to do that, to kind of clean house and then start with a clean slate in terms of, okay, I need to regroup, refocus, and restart my practice. So I think a censure would be appropriate. But if you all are not inclined to do that, then I do think a probation would be appropriate. I don't think 2 years is necessary, because I've already been in this process, in the system for 2 years without any issues. I think a shorter probation period would be more appropriate. So I would ask for a public censure or a probation of a shorter period of time.
And do you agree with that you have not filed an affidavit with this court?
That is correct.
And so, under our rules, is there a procedural mechanism for probation?
I think you have the discretion to order probation and for me to do that, but I don't see why you wouldn't have the discretion to do that. You guys have the ultimate you have the ultimate authority on discipline. And so, for example, like the prior party, if you declined their request for censure, right, and went with probation, then there would be a period of time that person would have to get that probation plan in place. So the same situation would apply here.
Any further presentation?
I have none.
Do we
There
have
are
any
no
more,
other questions?
any more questions?
Counsel, since
Yes.
this has occurred, you've indicated a couple times that you've not had any further issues. Have you had a supervising attorney, formally or informally, or someone else assisting you with your practice?
Certainly. Informally, there is a colleague of mine. That was a big, hard thing to, tell someone that you respect and that you think respects you, that, hey, I have this problem. I've often shared with John Taylor for years, and coming clean to him, right? I did that, and so I've worked with John, and I'll tell you what, that was probably what got me around the bend, is telling him, and then him having the confidence in me of saying, you're going to make it, no problems. Don't worry about this. You've got this. Let's go do a jury trial. And in fact, he starts jury trial on Monday, and I'm going with him, and I'm going to help him with that. And that was huge. That was a huge sort of, to have somebody say, who I respect and care about, say, you've got this, you can do it, don't worry about it. Not don't worry about it, but you're a good attorney. This is a bump, you'll get through it. come on, let's go try a case. So yes, I have informally had the support of not only him, but other attorneys who I've known throughout my career. I've told them and friends and family, and all of them are 100%
So
behind me.
you
Yes.
had said Carly Booth was going to be your supervising attorney. Did that not work out, or?
I think she didn't really understand what that process was. That was someone that Ann McDowell had found for me at that point, because I wasn't prepared to tell those other attorneys that I know and work with, and so Carly didn't even though that was somebody that Ann and I had worked with together to find. Carly had no idea what that entailed, and so I think that was part of the problem, is that we sat down and we met, and she was sort of like, I don't know what I'm supposed to do. Thanks for the list of cases, keep me apprised, and then that sort of fizzled from there. But I would say that if I was to get a practice monitor, that would be a requirement of the probation. I would ask John Taylor to do that for me, and I suspect that he would say yes to that. I anticipate that he would say yes on that, since we are right there together.
Any more questions? All right, thank you, counsel.
Thank you.
May it please the court, just to address a couple of things that Ms. Owens brought up in her arguments. She claims that AR had a birth certificate that she was not providing to her, and that was what's slowing up the time period that she was requesting this. I would just focus the court's attention on Volume 3, Exhibit 26. These were multiple emails that AR was sending to Ms. Owens, specifically during the summer of 2016, asking her, I haven't heard from you. What are the next steps that we need to take in order to get this case processed? And I would expect that if the holdup to move forward with a case was merely receiving information from a client, there would be some sort of documentation, an email, or something showing the attorney asking the client to provide that information so we could move forward with your case. And there was simply no evidence provided by Ms. Owens showing that she was making this request from AR to get this birth certificate. I would also note that the birth certificate that Ms. Owens is apparently referring to can be found in Volume 3 of the record at page 182. It's Exhibit 34. She sent this through an email along with other information that the investigator Terry Morgan from her office was requesting from her, asking her for her case file in this case. And as part of the materials that Ms. Owens provided to her office regarding AR's case, the birth certificate was one of those documents. So I can't tell this court when Ms. Owens received the birth certificate. I just know that she sent an email on February 6, 2017, and along with the materials that she provided to her office, the birth certificate was amongst those materials. With that, I have no further statements.
Do we have any questions? Seeing none, thank you, counsel.
Thank you.
Thank both of you for your arguments this morning. Court will take this matter under advisement. That concludes this